Hi. We're going to discuss judicial nomination, a failed judicial nomination, the nomination of Goodwin Liu to the U.S. Court of Appeals for the Ninth Circuit. Liu is a professor at the University of California, Berkeley, where he's also associate dean and an outstanding young scholar. But he came into what might be called the judges' war, the growing conflict between liberals and conservatives, Republicans and Democrats in the Senate over judicial nominations and conflicting views of the proper role of the judiciary in American society. Liu, in many ways, is a model of the American dream. His father was an immigrant from Taiwan who was a doctor in rural Georgia before moving to California, where Liu had an outstanding academic career, including in a Rhodes Scholarship before he became a Supreme Court law clerk to Ruth Bader Ginsburg and moved on to an outstanding academic career at the University of California, Berkeley, winning many awards and becoming a member of the prestigious American Law Institute. Unfortunately for Liu, he wrote many articles, which is what's necessary to become a published tenured professor. Those articles outline Liu's theory of constitutional interpretation. He takes a view of the Constitution. It's a living document, something that you may hear all the time, one that can adjust for the times. And in this adjusting the Constitution for the time, Liu was in the process of discovering new constitutional rights. A constitutional right to welfare, a constitutional right to health care, a constitutional right, some say, that would be broad enough to cover almost anything. This was disturbing to conservative members of Congress who tend to be more originalists. The Constitution means what it says. It has a historical context, and it's a limiting factor on the power of government. Once the Constitution loses those limits, they will tell you, it serves little useful purpose at all. The real fear is that what's happened in the last 50 to 60 years is that instead of having the Constitution as a fixed object in history with fixed meanings, we've come to the place where the more elite law schools and institutions and journals conduct themselves as kind of a continuing constitutional convention, rewriting the Constitution every 5 minutes or every month, with the courts ratifying those things later and turning them into law, so that we discover the Constitution means things that it never meant. If anything, Liu was a poster child for that position and a target of those concerns. Now, one of the things that got Professor Liu in trouble was that during his career, he had made testimony at the nomination of other people, two particularly, Justice Alito to the Supreme Court, and Justice Roberts, now the Chief Justice, when he was nominated to the Supreme Court. Professor Liu's language was perhaps colorful, one should say, but they were words he would learn to regret, because he's had to apologize for the comments that he made about the Chief Justice and the comments he made about Justice Alito. This puts him in an extremely awkward situation. If the apology was necessary, the Republicans would accuse him of being intemperate and lacking judicial restraint. If no apology came at all, he would be arrogant and pillared before the committee. He chose to apologize, putting himself in a position where it's difficult to say that he didn't lack restraint. Another problem is he had to tell the committee that he recognized that everything that he'd written in his articles over the last 18 years was not a proper basis for making judicial decisions. Well, then he promised the committee that he would be guided by what the law actually was and not what he'd expressed as his belief over his entire adult life. What a promise that was. And should anyone be surprised that there were those in the committee who were not willing to accept that kind of guarantee? Democrats said they shouldn't, and Republicans refused. A third problem with the nomination is what's called the extraordinary circumstances. A group of senators, when they were in a deadlock during the Bush administration, broke that deadlock by promising that there would never be a filibuster of a judicial nominee unless there were extraordinary circumstances. Democrats were now saying that, well, this situation with Professor Liu was not an extraordinary circumstance. Republicans disagreed. What could be more extraordinary than a professor who had written essentially that the Constitution, in their view, that the Constitution meant whatever the judges thought it meant, that believed so broadly that it could be applied to so many of these areas which are themselves hotly political. It is somewhat tragic that so talented a person has lost his shot. But we should also remember that not that long ago, a Republican nominee for the D.C. Circuit who was Hispanic was denied on similar grounds from the left because they didn't like his right-wing thinking. There was once a time in this country when judges were permitted to serve on the basis of character and because the president had chosen them. But that time is long gone, and the conflict over the meaning of the Constitution, these warring camps between limited government and stricter readings of the Constitution and expansive reading of the Constitution, are no longer just matters of judicial philosophy. They are matters of core political thinking vital to the Republic, and it's appropriate that the Senate act to impose its view of what is best for America in voting. Thank you.